Hello viewers and welcome to Rajput Jain and Associate. Today we would be discussing about the different aspects of a dormant company in India. So starting with the meaning of dormant company. What is a dormant company? Dormant company is basically a company which is not undertaking any business activity. These types of companies are formed for a future project or for holding an asset or intellectual property and thus do not involve in any significant accounting transactions. Dormant company, being an inactive company, is required to file an application with the registrar of companies in order to get their status changed from active to dormant company. Now in the above definition, one important part that we have discussed is that the dormant company shall not undertake any significant accounting transaction. By this we mean that the company shall not make any payment or indulge in any transaction except for making payment of the fees to the registrar of companies or making payment towards their regulatory compliances, undertaking allotment of shares, making payment in respect of maintenance of their office and records. Now having discussed about the meaning of dormant company, we will now discuss about the conditions which a company is required to adhere to in order to obtain dormant status. First of all, no inspection, inquiry or investigation would have been ordered or carried out against the company. Also, no prosecution be initiated or pending against the company under any law. Company should not be in receipt of any public deposit, and in case of any, they should not be in default of payment of interest on the said deposits. Company should not be having any outstanding loan, whether secured or unsecured. In case they are in receipt of any outstanding unsecured loan, then the company must have obtained the consent from such lenders prior. Company shall not have any outstanding payment in respect of taxes, dues and duties being due towards the central government or any state government or local authorities. The company must not have defaulted in payment of any sort of statutory dues. Also, the securities of the said company shall not be listed on any stock exchange, whether within or outside India. Now, where the company adheres to all the above mentioned conditions, they need to ensure the readiness of certain aspects. First of all, the said company shall not be carrying any business or operation and must not have made any significant accounting transaction during the last 2 financial years. A complete statement of assets and the liabilities be formulated and submitted by the statutory auditors of the company. Also, a no dispute certificate shall be obtained from the management or the promoters of the company. Now, after complying with the above conditions and prerequisites, the company can apply for the dormant status by undertaking the following steps. First of all, the directors of the company shall call for a board meeting to pass a resolution for the approval in respect of making application and to call for the extraordinary general meeting for getting the shareholders' approval. After this, the board meeting be held at the designated place and on the decided time as provided in the board notice. Then, the board of directors shall pass a resolution authorizing a director to make the application for obtaining the dormant status with the registrar of companies. The company secretary of the company shall draft and serve the notice of general meeting to all the requisite members. Auditors or the chartered accountants are to be communicated about the preparation of statement of assets and liabilities. Directors will then be required to hold the extraordinary general meeting and get the approval of the shareholders by passing off a special resolution. After this, the authorized signatory shall file the e-form MGT 14 with the registrar of companies. Now, in MGT 14 form, the details in respect of the approval which has been received from the board of directors and the shareholders is to be filed. After communicating to the registrar of companies, the applicant shall file the form MSC 1 with the registrar of companies containing the application for obtaining dormant status. Now, along with the application, the applicant is required to file certain attachments like the certified copy of board resolution, certified copy of special resolution, auditor's certificate showing the statement of assets and the liabilities of the company, latest financial statement and annual return of the company, no dispute certificate being issued by the management and the promoters, consent of lenders where any unsecured loan remains outstanding. Once the application and the documents are verified and the same is found appropriate, the registrar of companies will register the name of the company in the register of dormant company, and the said company will enjoy the status of dormant company for a maximum period of 5 years from the date of grant of dormant status. But again, though the company has been provided the status of an inactive company, there exist certain compliances which they need to adhere to. Once the dormant status is achieved, the dormant company is required to file the return of dormant company after the end of every subsequent financial year. Now, as discussed earlier, the company will enjoy the dormant status for a maximum period of 5 years. However, it is the duty of the directors to make an application to the ROC to obtain the status of active company before the expiration of the said 5 years. Now, in case the company fails to make an application, the registrar will be free to strike off the name of the said company from the register of dormant company, and thus all the compliances of an active company would be applicable on the said company. So this was all about dormant company. Hope you like this video. For any help required, do contact Rajput Jain and Associate, or you can also visit our website carajput.com. Thank you.